There's a long list of things that you're supposed to turn into your bankruptcy attorney so that your bankruptcy attorney can prepare your bankruptcy petition for you. And also, those are things that the bankruptcy attorney must also turn into your bankruptcy trustee so that the bankruptcy trustee can evaluate your case. The bankruptcy trustee is a bankruptcy administrator whose job it is to see if you are committing any bankruptcy crimes, have you properly exempted, i.e. protected, your stuff, and can you keep it, or do you simply make too much money to file a Chapter 7 bankruptcy and you really should be in a Chapter 13 paying a payment plan? I'm only licensed in California. I'm not your attorney, and
This is not legal advice.
you have to turn in your proof of income. Most of the time, that's going to be 60 days worth of pay stubs. It could also be, if you're self-employed, a profit and loss statement for the last 6 months or 7 months, or if it's a profit and loss statement, up to a year or even 2 years. You have to turn in your tax returns for the last year. The most recently required to be filed tax returns have to be turned in. If you own a corporation or an LLC where you have to also pay sales taxes, then you've got to turn in those. You have to turn in your corporate tax returns as well. Anything that you have to file, you got to turn in the most recent ones. And if you haven't filed taxes for a while, you may have to file taxes before you file your bankruptcy case.
Even if you're filing a personal bankruptcy and not a corporate bankruptcy, if you own a corporation, you've got to turn in those tax returns.
Income is actually broader than that, because what if you're married and your spouse is not filing a bankruptcy with you? Well, you have to turn in her or his pay stubs as well. Or if that person is self-employed, those profit and loss statements. They all have to be turned in. If your income is Social Security or unemployment, you have to turn in that stuff too. It all has to be turned in. You have to prove your income.
Even food stamps.
Even if your income is not going to be something that gets counted in the means test in your bankruptcy, so for instance, Social Security or veterans benefits, you still have to turn in the proof of what that income is. If you're married and living apart because you're separated, maybe you won't have to turn in your spouse's proof of income. If you're married, separated, living together in the same house still, you're going to have to turn in the income. The bankruptcy code says that we have to turn in the household income. So that's everybody. Even if your kids are working, you got to turn in that too. If your mother-in-law lives there and she's on Social Security, even though Social Security for you is not counted in your bankruptcy income for the means test, your mother-in-law's Social Security is counted because it's not your Social Security. So the whole household income has to be turned in. So if you're separated and living apart and your new friend has moved in with you and is working, that person's income has to be turned in because it's household income. Has anybody sued you? You may have to turn in the lawsuit as well. The bankruptcy trustee likes to know why you're being sued. Do you have the right to sue anyone for money or property where you might win? That's got to be turned in. If you have the right to sue anybody where you might win, even if it's not a sure thing, you still got to tell them about it. Even if the lawsuit's not filed.
Or even if you don't want to file the lawsuit or don't plan on filing the lawsuit.
Has anyone died who might leave you any money or property that you haven't yet received? You got to tell them about it. Whether it's in a trust, whether it's because of a will, whether there was no will or a trust, if you stand to inherit something, you got to tell them.
If someone dies and you might inherit from that person during the 180 days after the case has been filed, you've got to tell your bankruptcy trustee.
Do you own any stocks, bonds, mutual funds, or investments of any sort, including cryptocurrency, even if it is in a Cash App account or a Venmo account or any sort of similar type of account? You got to tell them about it. If you've got a Robinhood account and it's got some money in it, you got to tell them about it. Everything. You have to tell them about all bank account statements and turn those in. Bank account that your name is on, whether it's with your mom, your son, your brother, your corporation. If you are a signer on an account for a corporation where you are some sort of a manager, even if you don't own the corporation, everything that you can possibly put a signature on, you got to tell them about it. Do you own or operate a business such as you're driving Lyft or Uber or Instacart, or you have a handyman business, or you do landscaping on the weekends or mechanic work, where you receive just cash for the labor that you do, you got to tell them about it. And then you have to turn in a profit and loss or some sort of a statement from Uber, Lyft, or Instacart to prove what the income is. But then you can still also deduct, of course, the mileage and or the gas that you spend on driving around for Lyft, Uber, Instacart, whatnot. If you breed cats, that's a small business. You got to tell them about it. If you own an LLC or an S-Corp, and then you've got to tell them about it. You got to turn in the paperwork that proves that it's created and that you own it, and turn in the profit and loss statement, and you got to turn in all the tax returns associated with it. If you normally do sales tax returns, then you've got to turn in those too. They want all the tax returns, all of them, not just some of them, not just your personal, everything, kind of like the bank accounts. In California, where I am, which is a community property state, then you have to turn in all the same information about your spouse, whether your spouse files a bankruptcy with you or not. Unless you're separated, then maybe you don't have to. Probably have to discuss that with your bankruptcy trustee.
And your bankruptcy attorney.
Their job is to see if there are things they can take away from you that can include community property. Or in other words, things that your spouse thinks that they own, except that they co-own it with you. And then if you file a bankruptcy, then they co-own it with the bankruptcy trustee. Basically, a bankruptcy trustee owns everything you own, unless it's exempt and protected, and you don't really know that immediately. Your bankruptcy attorney should know pretty well, but you have to disclose everything to your bankruptcy attorney. You have to disclose everything about your spouse's income, property, etc. And if you are separated, maybe you don't. If you're separated and living together, you probably do have to turn in the stuff, because guess what? If you're separated and living together, how do they know you really are separated, except that you said it? There's no corroboration, there's no proof, if you're still living together. So we talked about income, and since I'm in a parking lot, I'll talk about cars next. You got to talk about cars. You got to turn in your registration. You got to turn in your proof of insurance on the car. If you don't have insurance on the car, you've got to get insurance on the car unless it's not operational. If it's not operational and you're not driving it, you have to make sure you don't drive it. So that's the thing. Car insurance, car registration. If you owe money on it, then you have to get a statement for the car to show the balance on the car. And then you also have to turn into your bankruptcy attorney and the trustee proof of the value of the car.
Go to the Kelley Blue Book at www.kbb.com and look up the private party and the trade-in value, and turning both of those to your attorney.
For all cars that you own, whether it's in your name or not, for all cars that you own jointly with your son, your brother-in-law, your sister-in-law, your mother-in-law, it doesn't matter. If your name is on it, you got to turn it in. If you own it and your name isn't on it, you still got to turn it in. So it's registration, insurance, value, balance. What about houses? Same basic stuff as the car. Registration, insurance, value, balance. Of course, there's no registration for the house, and typically they won't actually ask you for a deed. But if you own the house jointly with somebody who is not your spouse, so that you only have to protect your half of the house, then you are going to want to turn in the deed to the house that shows that you co-own it with somebody else. A mom, a friend, your brother. If it's somebody that you're married to, though, you only get one protection for the whole house for both of you in community property states such as California, where I am. I'm not licensed anywhere else other than California. California is it. I am not your attorney. This is not legal advice, but it might help your golf game. If somebody has a lien on your house, such as for solar, maybe they have a mortgage, you'd have to turn in that too. You have a second mortgage, you have to turn in that statement too. But something like solar might also have a contract and something called a UCC1 filing. This is a specific kind of lien that they can have on a house, and it's a little bit different than a mortgage, but if you turn in the proof of the UCC1 filing, then it proves that basically you have the equivalent of a mortgage, and it reduces the amount of equity in the house that has to be protected. So you want to dig that stuff up too. If somebody sued you, got a judgment against you, and put a judgment lien on the house, you've got to turn in that to your bankruptcy trustee and also your bankruptcy attorney as well, because that shows how much equity there is in the house. Also, if there's a judgment lien on the house, maybe your bankruptcy attorney can take it off of the house. But you got to tell him that there's a judgment lien on the house so that he knows that there's something to do about it. If you don't tell him, then he doesn't know. And how do you find out? You go to the county recorder's office and you ask. You look up your own name and figure out if there's a judgment lien, if somebody sued you and put a judgment lien on your house or not. That's how you do it. So you got to take a trip to the county recorder's office. Yeah, I know you don't want to. Do it anyway.
Even if you were never served a summons and complaint, do it anyway.
In the county that you're in, there may be a website where you can go and look and see if there's a judgment lien on your house. You have to just search your county website and figure that part out. Maybe your attorney already knows if there is such a county website that he can check. Ask him to do it.
You're looking for the grantor-grantee index.
So if you have any crypto accounts, you've got to turn that into your attorney, and he turns it into your bankruptcy trustee. On the subject of spouses and lawsuits, if you've been divorced in the last 4 years, you've got to turn the final divorce decree to your bankruptcy attorney so that he can turn it into the bankruptcy trustee. It proves what the property split was in the divorce, how much you got, how much the spouse got, and also what are you paying for family, child, or spousal support, which in a bankruptcy court they call a domestic support obligation.
Bloopers and outtakes. If you are paying support, you have to tell your bankruptcy trustee and your bankruptcy attorney.